This episode contains analysis based on public records, court filings, and established constitutional law. It is not legal advice. It is not a determination of guilt or innocence. It is a documentary examination of how government systems function and what happens when they don't. Because today we are revisiting the $25,000 question. This is Delta Deep Dive, and today we dive into how a single misdemeanor bond, one that doesn't exist anywhere else in Michigan, put an entire county on the edge of a federal lawsuit. Reed was charged with one misdemeanor count of stalking. Not aggravated, not felony, not domestic, not violent, no threats, no PPO, no pattern, no escalation, no aggravators. And yet, Magistrate Lacard set his bond at $25,000 cash. That number doesn't just stand out, it detonates. To understand how extreme this is, we need to look at the only comparable Michigan case we could find. The Sharon Moore case, December 2025, Washtenaw County. Moore was charged with felony home invasion, breaking and entering, misdemeanor stalking, threatening self-harm with knives in front of the victim, showing up at the victim's home after being fired, repeated unwanted calls and texts, a mental health crisis requiring intervention. His bond? $25,000 cash. The same number Reed got for a single misdemeanor. No violence, no weapons, no break-ins, no threats, no mental health crisis, no escalation, and no felony. This is the comparison that exposes everything. Across Michigan, first offense misdemeanor stalking bonds fall into a predictable, boring, consistent range. Wayne County, $500 to $2,500. Oakland County, $1,000 to $5,000. Kent County, $500 to $2,500. Marquette County, $500 to $1,500. Delta County, now this number is historical, $500 to $2,500. These numbers don't spike. They don't jump. They don't leap into felony territory. And after reviewing arraignment logs, district court dockets, appellate cases, news archives, statewide judicial data, there is not a single documented case in Michigan where a first offense misdemeanor stalking charge received a $25,000 cash bond. Not one. So again, the $25,000 question. Why this number? Why this case? Why this defendant? Michigan judges are not free agents. They operate under the Michigan Code of Judicial Conduct, and the rules are explicit. Canon 2A, a judge must avoid all impropriety and appearance of impropriety. Canon 2B, a judge shall not allow family, social, political, or other relationships to influence judicial conduct or judgment. Canon 1, a judge should uphold the integrity and independence of the judiciary. Canon 3A1, a judge shall be faithful to the law and maintain professional competence in it. Canon 3A4, a judge shall be patient, dignified, and courteous to litigants. These aren't suggestions, they're requirements, and they matter because of what comes next. Bias isn't about proving someone's inner thoughts. Courts don't need that. They look at relationships, interests, and conflicts. And the Supreme Court has said, the probability of bias is enough to violate due process. Caperton versus A.C. Massey Cole County. Probability, not certainty. So let's talk about the probability. To understand the full picture, we need to talk about Emily DeSalvo. Emily wasn't just a name in the background. Before becoming the county administrator, she served as the district court administrator, the person responsible for coordinating court operations, managing administrative processes, and working closely with judges and magistrates. That role matters because it placed her in a position of professional proximity to the very officials involved in Reed's case. Later, when she transitioned into the county administration, her tenure ended after a change in county leadership. The shift wasn't about the criminal case, but it did mean that Emily's departure intersected with people and events connected to Reed's broader circle. And here's the key point. Kelly forwarded the lawsuit filed against her directly to Emily DeSalvo. Not to an attorney, not to a clerk, not through formal channels, to Emily. That single action shows a level of familiarity and comfort that goes beyond routine communication. It suggests that Kelly viewed Emily as someone positioned close to the courthouse ecosystem, someone whose insight or awareness mattered. When you combine Emily's prior role inside the district court, her working relationship with judicial officers, and Kelly's decision to loop her into a legal dispute, you get a clear appearance of interconnectedness. And in judicial ethics, appearance alone is enough to raise concerns. Now, Kelly wasn't just the complainant. She was politically active, socially connected, aligned with the same individuals Lockhart was aligned with, and openly hostile towards people in Reed's circle. She had forwarded legal documents to Emily, communicated with political actors, and inserted herself into local power structures. When a complainant is that close to the court's administrative leadership, and that leadership is close to the magistrate, the appearance of bias isn't subtle. It's structural. And under Michigan's Judicial Conduct Code, that alone is a violation. Reed was politically active. He aligned with people the magistrate's associates opposed. He criticized local officials. He participated in public discourse. All of that is protected speech. The Supreme Court in Hartman v. Moore said, the government may not retaliate against individuals for engaging in protected speech. If the bond was inflated because of politics, because of who Reed supported, or who he criticized, or who he stood next to, that's not just improper, it's unconstitutional. Equal protection requires that comparable situated defendants be treated alike. But here, defendants with violent felonies, weapons threats, domestic assaults, and repeat offenses received lower bonds than Reed. The Supreme Court in Yick-Wo v. Hopkins warned, the Constitution prohibits selective enforcement based on arbitrary classifications. If Reed was singled out, not because of risk, but because of politics or personal relationships, that's an equal protection violation. This is the moment that turns a questionable bond into a constitutional landmine. When Reed was booked, the jail reviewed his medical conditions, religious dietary needs, and the facility's limitations. And the jail told the court, we cannot safely house him. This almost never happens. Jails do not contradict judges unless something is seriously wrong. And then the jail did something even more extraordinary. They lowered the bond. That is the clearest evidence that the original bond was arbitrary, unsupported, excessive, and unconstitutional. It also proves the county had actual notice that the magistrate's decision was defective. And in civil rights law, notice is everything. Under federal law, specifically 42 U.S.C. 1983, the county faces exposure under multiple theories. 1. Excessive bail. Eighth Amendment bond must be no higher than necessary. $25,000 for a misdemeanor is facially excessive. 2. Due process. Biased adjudicator. Even the probability of bias violates due process. 3. Equal protection. Disparate treatment. Violent offenders received lower bonds. 4. First Amendment retaliation. If politics influence the bond, that's unconstitutional. 5. Abuse of process. Using bond as leverage or intimidation is unlawful. 6. Monell liability. County responsibility. The county is liable if it failed to supervise magistrates, allowed political influence, lacked bail safeguards, or ignored patterns of bias. This is the county's biggest exposure. So, we return to the one-liner that anchors this episode. The $25,000 question. Why was a misdemeanor defendant with no violence, no threats, no pattern, given a bond higher than many violent felons? Why did the jail have to intervene? Why did the county allow a magistrate with known conflicts to preside? Why did no one stop it? These aren't just questions for a documentary. They're questions a federal court may one day ask. And the answers could cost the county far more than $25,000. This episode isn't about guilt or innocence. It's about systems. It's about power. It's about what happens when the people entrusted with neutrality let personal relationships and politics seep into the courtroom. Because when that happens, the Constitution doesn't bend. It breaks. And when it breaks, the county pays. This has been Delta Deep Dive, and that was the $25,000 question.